Now, last week we looked at the nature of property and how it was a social construct and how ephemeral it really was. We also looked at the sources of law in Ireland, and we discussed the justifications for intellectual property. So we're finished with those things now, and today we're going to start looking at copyright proper, except we're never really finished with any of those three things. We're always going to be thinking about the justifications for intellectual property. We're always going to have to deal with the different sources of law, and we're also going to have to deal with intellectual property as a property right. But from now on, it'll probably be a little bit less abstract and a bit more detailed. So the first area we're going to look at is copyright, and then after that we'll look at trademarks, and then after that we'll look at patents, and there'll be one or two things along the way. Okay? So copyright is probably the area of intellectual property that people are most familiar with, and it's the one that people encounter most in their day-to-day lives. So, copyright is a property right created by the law of a country. That sounds a bit strange, but I wanted to stress there the point that copyright is guaranteed by national government rather than international, or it's a very much a national right, unlike some of the others. Okay, that grants the creator of an original work exclusive rights to its use and distribution. So the author of a work has these special rights. The works can be books, film, not music, sound recordings, or whatever. Copyright law prevents others from making copies, selling copies, or exploiting the works in some way. Now, there are two justifications for copyright, two approaches to take as to why we have copyright. We sign the attendance sheet there, everybody got it? Yeah. Okay. So the first is the instrumental justification. So if we provide an incentive to authors to create new works, then there'll be more works in circulation, and that's a good thing. So the idea is that without that incentive, people wouldn't produce as many works. So conceivably, I might potentially be Ireland's greatest rapper. It's possible. But without copyright, it probably wouldn't be worth my while. You know, I have a mortgage, I have bills to pay, and I might not be prepared to do that unless there was some way of making a living from it. So you might all be deprived of my fabulous art. But this instrumental justification is all about the benefits copyright gives to society. So copyright is good for everyone. That's why we have it. Copyright means that we will have more works of art and literature and music in circulation. The author's rights justification then is a very different approach. The author's rights justification for copyright is that if a person creates something, it's an extension of them and their personality and their rights as a person. And so they should have control over it. So if you write a great song apart from the money, apart from the benefits to society, it's yours and you should have control over it. And so these are the two main justifications for copyright that we have. And while both of them come to the conclusion that we should have copyright, when it comes to some of the details, you could see how, depending on which justification you were most interested in, you might come to a slightly different conclusion or a slightly different decision about the details. Here's a quote from the WIPO, the World Intellectual Property Organization, that the purpose of copyright is to encourage a dynamic culture while returning value to creators so that they can lead a dignified economic existence and to provide widespread, affordable access to content for the public. Which justification do you think this is drawing on more? The instrumentalist one or the author's rights one? It's definitely, I think, instrumental. It's all about putting content in circulation. It's like if we didn't have copyright, then we wouldn't have as many books or we wouldn't have as much music. It's not so concerned with the rights of the author, although it does acknowledge, well, you have to give them some money so they can survive, or we won't have these things. But the purpose of copyright is so we can all have these wonderful things. So the example we're probably all most familiar with is the idea of a copyright in a book. So if you write a book, that book is yours. You own the intellectual property. You own the copyright in that book. So if we say, take J.K. Rowling, who wrote Harry Potter. So she wrote the first book, and then the author can give a book publisher the right to print copies of the book and sell them. So J.K. Rowling would have found a publisher, and in exchange for the right to print copies and sell them, the publisher would have given her X amount of pounds. There was also probably some sort of deal where for every book she got whatever. But that's a contractual arrangement between her and the publisher. But she gave the publisher the right to print the copies of her work. Now, if you go around printing copies of a book without her permission, then you're breaking the law. So the book publisher can print because J.K. Rowling gave her permission, but she hasn't given you permission, so you can't go printing copies of Harry Potter. And as we all know, she also gave the right to make a movie of the books to someone else in exchange for presumably a huge wad of cash. So a book is the kind of thing we're most familiar with. But you can have copyright in lots of things, and we'll see some of those in a while. Now, the sources of copyright law then, pretty much like any other kind of law in Ireland, comes from the common law. There's also statute, so acts of parliament. There's constitutional law in Ireland and a fair whack of international law as well. And so we have these various sources of law exerting different kinds of pressures, which result then in the precise configuration that we might have in Ireland. When the US was founded, the founding fathers thought that copyright was so important that they wrote it into the Constitution. And even the first version of it, even free speech and the right to bear arms, were tacked on. This was in the core thing. So even more important than guns for Americans was copyright. Do you think this phrasing here, this is Article 1 of Section 8, Clause 8 of the Constitution of the US, do you think they were drawing on the author's rights tradition or on the instrumentalist justification for copyright here? So it says, to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. That's very much instrumentalist. Okay, so when I was saying last week, let's imagine we're all moving to an island and or a new continent and we're setting up a society. Will we have this intellectual property thing? They had that very question to ask. And they decided that they definitely wanted intellectual property because it would benefit society as a whole. So to promote the progress of science and useful arts. So having copyright and having patents would develop society. It wasn't so much about, individual writers or authors or inventors should have A, B, C, and D. It was having this copyright thing will develop our society. Now, so let's look at some of the law then. So we'll be looking at case law and the common law, and we'll be looking at some constitutional law and eventually some legislation. Ireland lays claim, this isn't a typo, to the very first recorded copyright judgment. So back in approximately 567, so about 1500 years ago, Saint Finian and Saint Columba, although they weren't known as saints at the time obviously, got into a bit of a dispute. So Saint Columba was studying under Saint Finian, and Columba borrowed a manuscript from Finian and secretly copied it. No, I don't think Finian actually wrote it. I think it was a psalter. Do you know what a psalter is? I'm not sure. I think it's a version of the Bible in vernacular form or something. I'm not sure. Anyway, you must remember this wasn't a time when you could, pop into Waterstones and just pick up something or order it on Amazon. Books weren't that easy to come by. And I'd say copying one was no mean feat either. So anyway, Columba copied a book that was owned by Finian, although, like I said, I don't believe it was written by him, but I couldn't be sure. And Finian wasn't happy about that, and so he demanded that Columba hand back the copy of the book. And Columba said no, and so they took the matter to King Diarmait MacCurl. I'm not sure. You know how to pronounce that better than I can? Is it Curville? Do you pronounce the B? Curville. Yeah. So Diarmait MacCurl, who was the High King of Ireland at the time. So this is, remember we were talking about, the law being based on decisions of the village chief or the priest or the king. They took their dispute to the king. Obviously they were men of substance. They got an audience with the king. And the king ruled that to every cow its calf and to every book its copy. So a calf belongs to a cow and a copy belongs to the book. And so he made Columba give back the copy of the book to Finian. It seems this dispute was also a contributing factor to a war. There was a big war sometime after, and you might remember from school the story of Diarmait and Grania, and it's all mixed in there somewhere. But anyway, so Ireland does claim to have the oldest recorded copyright dispute. But we move forward then 1,000 years and a bit, and the most important and I suppose first real piece of legislation that we would recognize as modern copyright was from 1710. So before this time, there was control on who could print what, but that was tied up a lot with censorship. And there was demand at the time for a more liberal system. where the government didn't have quite so much control over what people could print. And there's a whole story there, but I won't go into that today. But it's actually quite interesting. But what we're interested in today is the first modern law on copyright was from 1710. And it was in English, but we might struggle to, well, legislation is difficult to read at the best of times, even if it was written last week. But 1710, the language might be a bit tricky. So this was the first time copyright was regulated by the government rather than by private parties. And it gave a copyright term of 14 years with an option to renew once. And then once the term expired, then the works were in the public domain, which meant anybody could do what they wanted with them. Or so it was thought. There was a bit of a dispute. So the booksellers, who had been producing books all along, quite happily, were not happy that copyright expired after the set term. And so they went to court with quite an interesting argument. Their argument was that copyright existed in the common law. And although the Statute of Anne was guaranteeing authors' rights for 14 or 28 years, that wasn't a substitute for what was there before. It was just a supplement to that. So they were arguing that in addition to protection from the state, there was this underlying common law copyright that had been there all along and was being supplemented by the Statute of Anne, but not being taken away by it. So there was a very important case, or a series of them rather. The first one there was Millar v. Taylor from 1769, which, if we were to do the math, you could see was after the well, anyway. So James Thomson had a poem called The Seasons, and this was published by Taylor after the copyright had expired. And Millar, who was the original bookseller, he had obtained the rights from Thomson to print the book, and he was saying that no, Taylor can't go printing that book now. And he argued that the copyright that Thomson had in his poem was a perpetual right in the common law. It was a right he had forever. And that the Statute of Anne didn't take that away. It just added protection, state protection to it for the period. But when the period was up, he still had it because it came from the common law. And Millar won that case, which concluded that, copyright was forever. So although the Statute of Anne protected it for 14 years plus another, he still had it at the end of that because it was a law, it was a right in the common law. This bit up here is worthy of some explanation. You see this kind of thing a lot when we talk about a case. So if we're talking about a court case, there'll be two parties. It'll be somebody v. somebody. The first name is always the person who has the problem that he wants the court to resolve. And the second name is the person who's allegedly done something that they weren't allowed to do. So if you're up in court for committing some criminal act, in Ireland it'll be the DPP, Director of Public Prosecutions, versus Manning, say. If we were in Britain, it might be Crown v. Manning. But if it's two parties coming to the court to have a civil matter resolved, then the first person is the plaintiff or the complainant, but the person who is coming to court to say, come here, this guy's doing whatever, he must be stopped, or he did this to me, I want some money off him. And the second person is the person who's being hauled before the court to respond to this. So sometimes if you're reading about a case, the order of the names is assumed you know who's who. The first person and the second person there, okay? Now, they didn't have the interweb way back in 1769, and they didn't have Twitter or anything like that. And so there were these reporters that would sit in on court proceedings, and like journalists pretty much, if there was something important or significant, they would write up a report, and this would ultimately be published perhaps at the end of the year. Say 50 years ago in Ireland, you might have had a situation where a lawyer's office would have had a subscription to these things, and maybe every month or every couple of months in the post would have come some leaf sheets, bundles, that you would put into a folder so that you would have the latest up to date in every area of law. So these reports are what we have of old cases today. We might not have, for example, transcripts or anything like that. All we have is a book, like a yearbook of law where this would have been reported. And so in this case, this was one of them. And this here was the second one. So they would have been the rough equivalent of like legal newspapers of the day, where you would find reports of what had happened in the courts. In modern times, if you were to go to the High Court today, the case would just be given a number that wouldn't depend on any particular vendor of reports. And so you would just refer to the case using that number. But for older cases, we do have a variety of different sources. And sometimes the different sources actually reported different facts or different details. So you're not even sure exactly what happened because you have different accounts. But we refer to cases like this. So we have the name of the parties and then the reference here. So that's just an aside because you'll see that a lot. Okay? So that was Millar v. Taylor, and the publishers won that round. But across the border in Scotland, the same book caused the same problem, and the Scottish courts decided the exact opposite. The Scottish courts decided that, okay, there may have been copyright in the common law in the past, but now that we have this Statute of Anne thing, well, do you know what? After the 14 years, tough luck, your copyright's gone then. That the Statute of Anne supplanted, replaced entirely the underlying common law copyright that may or may not have been there. So that you can't have your copyright forever. Then finally, in Donaldson v. Beckett, not the same Donaldson that was in Scotland, actually, was his brother. The House of Lords finally ruled then in 1774 that copyright was not forever. That the Statute of Anne put limits on copyright, and there was no more common law copyright after that. There was only copyright by statute. So you got whatever was in the Statute of Anne. That was your deal. You got nothing more than that. So that was ultimately decided by the House of Lords. And in the US, you had kind of a parallel series of cases that came to largely the same conclusion. Now, if we zoom ahead to 1998, we have a very interesting case in Ireland, and this isn't interesting to us just because we're in Ireland. It's not quite so parochial as that. It is interesting to other people as well. A judge named Keane kind of rejected the logic of Donaldson v. Beckett. So this was a case, I think, involving a nightclub in Tralee, I think, that didn't want to pay the licensing fee for music or something like that. And also you will see in text, you'll see something like Keane J. They're not all called John. The J is short for judge. So you'd often see that. And he said that essentially copyright in Ireland was pre-legislative in origin and super-legislative in effect. So what does that mean? I'll give you a second there to read what he's saying there. So this is a quote from him. So he's saying the right of the creator not to have his or her creation stolen or plagiarized is a right of property, private property, within the meaning of Article 43.2 and Article 43.1 of the Constitution of Ireland. So if we were to get out the Constitution, or call it up there on the screen, there are parts that protect private property. And he's saying, do you know what? Included in private property is copyright. Now, it is arguable that the good people of Ireland in 1937-38, when they were devising the Constitution, had no interest in copyright whatsoever. They might not have meant that. When they talked about property, they were probably talking about the field down the road. But in this era, the scope of the private property guarantees in the Constitution of Ireland extend to intellectual property. And so he's saying here that the right to intellectual property comes from the Constitution, not from the legislature, not from laws that are passed by Parliament, but from the Constitution itself. Which is, that's a big deal, and it's a shift. And he's saying, as such, they can hardly be abolished in their entirety. Okay? So he's saying, even if there was no Statute of Anne, even if there was no copyright law in Ireland, people have a constitutional right to intellectual property because private property includes intellectual property in its meaning in Ireland. So even if the government abolished copyright tomorrow, let's say, the Pirate Bay Party from Sweden or something won a massive victory in the election, and we abolished copyright, he's saying that, but it's in the Constitution as private property. And he's saying that the Statute of Anne didn't abolish those rights that we have, that the Oireachtas can't abolish those rights. And then he goes on to say, which I thought was very interesting, that statements in some English authorities that copyright other than by statutory provision ceased to exist with the abolition of common law copyright are not necessarily applicable in Ireland. So he's saying, Donaldson v. Beckett, great. That's grand for you guys in the UK. But in Ireland, common law copyright was not necessarily abolished by that, because we have a constitution and it comes from that. So it seems to have kind of gone full circle. So in Ireland anyway, the point is that our right to intellectual property comes not just from the legislature, but it's in there in the Constitution if you read the Constitution broadly enough. Now, so a step back again now to 1886, so 100 and a few years ago. So copyright before this Berne Convention only applied nationally. So if you published a book in Britain, it was protected in Britain, but not so much elsewhere. So you had big problems with foreign translations of books where the author got nothing from them. You even had problems with people printing books in English in the Netherlands, say, and then importing them back into Britain without paying anything. And so they came up with this Berne Convention. It was driven primarily by some people in France. And this was a treaty. So we're only here now, half an hour. We've already had common law, constitutional law, and now we're on to international law. Like I said, all of these different forces, pushing and pulling. So the Berne Convention for the Protection of Literary and Artistic Works. And this was devised to provide international protection for authors. So before this, if you were an author in Britain, you were only kind of covered in Britain. You were getting screwed then when you went abroad, or when your works went abroad without you. And so this did two main things. The first thing it did was it gave foreign authors equal treatment. So if you were a French author, you got the same rights in Britain as a British author. And then it also committed signatory countries to minimum standards of protection. So there was a baseline. So everybody that signed up had to commit to a minimum amount. The equal treatment doesn't require much explanation, but the minimum standards are interesting. So one of the things it did was put in a requirement that copyright be automatic, so that an author doesn't have to do anything in particular for a work to be protected by copyright. So there was no formal registration required. So you didn't have to deposit your book somewhere with some central office in order for it to be protected. As it turns out, registration is normal in the US, and the US sails as close to the wind as it possibly can and still be compliant with the Berne Convention. And it even signed up quite late. So you might even argue that it's not really meeting its requirements. You could have a debate about that. But it does mean, for example, that in Britain, when you create a work, it's protected. You don't have to register it or do anything with it. It's automatic. It also protected derivative works. So it was a requirement that things like plays based on a book would also be protected. It was more targeted, though, at translations. So if you write a novel in Britain, the French translation of that is also protected, because that was one of the things that authors were getting screwed on. And then it set a minimum copyright term of 50 years after the author's death. So Statute of Anne was 1710, I said, wasn't it? And you got 14 years. Within 100 and a bit years, you're up to 50 years after your death. So that was quite an extension of the term.
You said that copyright is automatic.
Yes.
Without formal registration, how was you
Yes.
able to prove that you did produce the work?
Well, proving it is another thing.
Okay.
So the question is, if it's automatic and there's no formal registration required, then how do you prove it's yours? Yeah, that's a problem. But it did mean that an author wasn't going to get screwed in Spain for not meeting the formal requirements for lodging the book with some office somewhere. So it was to make it easier for authors to be protected abroad.
Okay.
And so removing all the formal requirements meant that by default then, it was by default, that was the point. So I guess if you published a book in Britain and then 10 years later, the Spanish translation came out, you can easily argue, well, hey, that's a translation of my book. But in day-to-day terms, you do have issues then with how do you establish that you're the author of something. That's an issue. So the United Kingdom signed up right away in 1886, along with France and a few others. As I said, the US took its time. The Irish Free State signed up in 1927. So again, it's interesting to see that so long ago, intellectual property was a concern for people. God knows the Irish Free State had its own problems, but still thought intellectual property was important enough to sign up. So the Berne Convention is still in force today. So you will still have laws of national parliaments meeting requirements set out in the Berne Convention. And that's an international treaty between lots and lots of different countries. And they all agree to equal treatment for foreign nationals and also minimum standards. And it's been extended and revised and many, many times. And pretty much everyone has signed up. I mean, I'm not sure if North Korea has signed up, but like even Cuba has signed up to this. Okay, so it's if we were to go through the legislation in Ireland or in the UK or in France, we would see the fingerprints of the Berne Convention all over it. There would be things just literally copied and pasted out of the Berne Convention into the laws of all the countries that have signed up. Okay. Now, so this brings us then to today and the question of what can be protected by copyright. So what can you copyright? And what's the threshold for achieving copyright in something? So in 1916, there was a judge who said that what is worth copying is worth protecting. He's basically saying, listen, if someone's going to the trouble of copying it, then it clearly has a value, which is setting the threshold quite low. In 2000, a different judge thought that was a bit too low a threshold. He's saying that it proves too much. He's saying it is possible that entirely mechanical labour may be saved by copying something produced by entirely mechanical labour involving no skill. So he was saying, well, this notion that anything worth copying is worth protecting, that's a bit too loose. The first case, actually, the 1916 one, was about copying exam papers, exam questions. There was a thriving business in mock exams, even back in 1916. And again,
you would think copying exams would be the least of their worries.
In 1916, you would think it was the least of their problems. Yeah. Now, so literary works are protected. Now, what are literary works? Well, books have been protected since at least 1710 in the UK. But the interpretation of literary works is really, really generous, really, really liberal. So lots of things can fit under the umbrella of literary works. Pretty much anything. So advertising slogans might, if they're not too short. Rail timetables have been considered literary works. Shopping list. And like I said, exam papers. And a big thing is that the quality of the work isn't a factor. Why do you think that is?
Quality is subjective.
Yeah, it's entirely subjective. Like, is copyright law going to decide this book is really good, so it deserves protection. This book is crap, so it's not worthy of protection. Like, that's not the business of copyright law. You know, it's just not it's not its place. So by not protecting stuff based on quality, it's really up to the market to decide what's good and what's bad. So this is from the Berne Convention as it stands today now, not the original one from way back. And you can see the scope of literary works is huge. The things that count as literary works are varied and broad. My favourite is choreographic works. So if I was to do a dance there, none of you would be allowed to copy it without my permission. Or could you? We'll see. Now, the definition in the Berne Convention is important because all of the signatory countries have signed up to this, so they can't deviate from this. So if Ireland decided to, in its copyright law, not include engravings and lithography, for example, then we wouldn't be meeting our obligations under the Berne Convention, and people might have a problem with that. So here are some quotes from two cases. The first is from 1900, and the second one is again that exam one. So the right, in my view, is given by the statute to the first producer of the book, whether the book be wise or foolish, accurate or inaccurate, of literary merit or of no merit whatsoever. So there the judge is saying, even if it's crap, it's still worthy of copyright protection. It may be difficult to define literary work as used in this Act, but it seems to be plain that it is not confined to literary work in the sense in which that phrase is applied, for instance, to Meredith's novels or the writings of Robert Louis Stevenson. In my view, the words literary work cover work which is expressed in print or writing, I think I must check that, irrespective of the question whether the quality or style is high. Again, pointing out quality is not the business of copyright law. Let's just check that quote there if there isn't a typo. So a whole bunch of things can be protected by copyright. Books, film, musical compositions, sound recordings, sculpture, photographs. Photographs pose a lot of interesting questions. Photographs are a tricky one. Drawings, engravings, plays, computer programs wrecked heads for a while. As a programmer myself, I would never have conceded the point, but many people felt that a computer program is just a series of technical instructions that there's no creative act there. It's just a set of instructions. Typographical arrangements, I'll explain. Databases were a tricky one. Came up with a workaround for those. Typographical arrangements are works of like layout. So if there was, say, we'll talk about this the next day, but if there was, say, a Sherlock Holmes book that was out of copyright, and you took the text of that and you produced a lovely PDF with a very nice layout, and you spent a lot of time, you expended a lot of labor and skill and judgment in producing that, the words don't have copyright in them anymore, but your typographical arrangement would. So we'll look at some of those the next day. I don't think we have time to go into any more detail on those. So a very broad range of things can be covered by copyright. Thanks, guys.